Hello, in this video, we're going to discuss the topic of torts, which is a class that you are most likely going to be taking during your first year of law school. The first thing you may be wondering is, what exactly is a tort? This is not a word that a lot of people have heard before getting into law school if they're not familiar with the legal profession. So torts is a class that discusses civil lawsuits brought by one person against another. So think, for instance, if someone causes some sort of injury to you and you want to recover for the money damages that you suffered as a result of that injury, you would bring some sort of tort lawsuit against that other person. So this is usually for injury, and you're usually seeking some sort of financial damage. So we're going to talk in specifics about the types of causes of action that are included in the broad subject heading of torts. Now, you can break torts down into two really big categories that we're going to talk about in more detail here. Those two categories are intentional torts and negligence. Now, when we're talking about intentional torts, think about that word intentional. If someone commits an intentional tort, it's usually the case that they intended a particular result. So they acted with some sort of intent. You can contrast that with negligence, where they probably didn't intend a particular result if they just acted negligently. They simply didn't act carefully enough. So take, for instance, if I pull my fist back and I punch someone in the face because I wanted to punch them in the face. I intended to cause that end result, the punching the person in the face. So in that instance, we're going to be thinking about intentional torts. On the other hand, if let's say I'm dancing wildly in the middle of a room and just not being careful enough, and I just so happen to fling my arm and hit someone in the face, I didn't intend to hit them in the face. If that other person can prove that I wasn't acting carefully enough, they might be able to sue me for, let's say, negligence, but would not be able to recover for an intentional tort. So we're going to start by discussing some of the common intentional torts that you're most likely going to be talking about during your first year of law school in your torts class. We're going to start with assault. And an assault is an act with intent to cause a harmful or offensive contact, and an imminent apprehension results. Now, the first thing to be aware of for this intentional tort, and all intentional torts really, is that they can easily be broken down into elements. So with the statement that I just gave you, you can think about this as an act, that's the first element, intent to cause a harmful or offensive contact or imminent apprehension of that contact, that's the second element, you need some sort of intent, and then third, the imminent apprehension results. So we need a specific result, that's the third element. All of these intentional torts can be equally broken down into manageable parts. And then your job is to simply see if each part is satisfied by the facts. So for instance, if I didn't want to actually hit someone, but let's say I just wanted to make them think I was going to hit them, I just wanted to scare them. So I pull my arm back, I swing toward their face, they see it coming, they think that I'm about to hit them, but I know that I'm just trying to scare them. And at the last minute, they jump back and I don't actually hit them, but they had that apprehension. They thought they were going to be hit. That would most likely be an assault. So I had an act, swinging my arm. I intended to cause apprehension, and the apprehension resulted. They thought I was going to hit them. Now, something to be aware of is that a lot of torts can also be crimes. So your jurisdiction may also have a crime of assault or assault and battery. That's going to yield a different punishment. Crimes are prosecuted by the prosecutor, even though they have the same name. Most of the time they have the same elements. When we're talking about torts, we're talking about the victims able to recover for monetary damages as a result of that tort that occurred. So there's some overlap there, which makes it a little bit confusing. Just make sure you're thinking about who the parties are and what remedy they're seeking. The next intentional tort we have is battery. Again, think about the elements of battery. Here we have a defendant acts with intent to cause a harmful or offensive contact, and a harmful or offensive contact results. So some sort of act, intent to cause a contact, and the contact results. So here, when I pull my arm back and I swing it at someone, when I actually make contact with that person, rather than simply like putting my fist close to their face and making them think that I was going to contact them, when I actually make the contact, that's when it becomes a battery rather than just an assault. And you're probably going to learn the doctrine of personal autonomy here, which says that the contact doesn't need to be with the person, him or herself. The contact can be with anything associated with the person. So for instance, if I'm carrying a bag on my shoulder and someone intentionally makes contact with the bag that's on my shoulder, the bag is essentially an extension of my person. And so I could recover for battery, even though the other person didn't touch my body, but touched the bag, which was connected to my body. You may cover the Garrett v. Daly case when you're talking about battery. In this case, the defendant pulled the chair out from underneath a woman who was trying to sit down. And when he pulled the chair out, the woman naturally fell on the floor. So even though the defendant didn't make contact between his person and this woman, by pulling the chair out, he knew that she was going to have a harmful or offensive contact with the floor, and he intended that contact. So this act of pulling the chair out from underneath the woman was enough to constitute a battery. Another intentional tort you may discuss is false imprisonment. Here, a defendant acts with intent to confine or restrain in a bounded area. Confinement occurs, and the plaintiff either knows of the confinement or is hurt by it. So act, intent to confine or restrain in a bounded area, actual confinement, and then knows of it or is hurt by it. Those will be your 4 elements for for false imprisonment. And with regard to that last requirement, the plaintiff either knows of it or is hurt by it. I'll give you an example. Let's say, for instance, I walk into a crowded classroom of students and I lock the door behind me. So we have the act, locking the door, intent to confine or restrain. I'm meaning to confine everyone to that room. Everyone is actually confined. And then I make an announcement and I say, hey, everyone, I just locked the door. You're stuck here for the next hour. That would be enough to constitute false imprisonment. Or let's say I didn't make that announcement. Let's say I don't say anything to the room full of people, so they don't actually know that the door is locked if no one tries to leave, but there ends up being a fire in the building. And because the door was locked, people can't get out of the room while the fire is raging through the building, and some people are hurt. That would also be enough to constitute false imprisonment. Intentional infliction of emotional distress is our next tort. Here, the defendant acts intentionally or recklessly and engages in extreme or outrageous conduct that causes the plaintiff to suffer severe emotional distress. So we're going to compare this on the next page of this sheet to negligent infliction of emotional distress. But I think this is a really good example of that idea of intent, especially when we compare it to negligence. A defendant is intending to cause not physical harm, not necessarily any physical contact, but intending to cause emotional distress. And in so doing, the defendant engages in extreme or outrageous conduct that does end up yielding emotional distress. That could be enough for the plaintiff to sue and recover for intentional infliction of emotional distress. Some of the other torts you'll see listed here are more with regard to property. So trespass to land, trespass to chattels, conversion. I'm not going to cover these in detail, but I just want to point out that, again, these are intentional torts, meaning that the defendant must act with intent to interfere with the other person's property, their land, their chattel, their item, whatever it may be. And so when you're thinking of your intentional torts, make sure you identify that the defendant acted with the requisite intent. Now, when you talk about intentional torts, it's a good idea to think about your intentional tort defenses. There are certain defenses that only go along with intentional torts. Similarly, you'll see that there are certain defenses that only go along with negligence. So you wouldn't use an intentional tort defense, for instance, in response to a negligence claim. You would only use it in response to an intentional tort claim. So the first intentional tort defense we have here is consent. If the plaintiff consented to the conduct, then the plaintiff cannot sue for that intentional tort. You may read the O'Brien versus Cunard case in your torts class. So what happened in this case was there were people who were disembarking from a ship, and as they disembarked, they had to be vaccinated. And every person who disembarked held out their arm so that the person at the end of the ship could provide the vaccination. And the plaintiff here, O'Brien, she was disembarking. She held out her arm, allowing the doctor, whoever's giving the vaccination, to inject the vaccination into her. And so she later sued for battery. She said, you intentionally harmed me when you touched me and injected this vaccine. I didn't consent to this vaccine. Even though she may not have known exactly what was going on when she held her arm out, this is looked at from the perspective of the defendant. Was it reasonable for the defendant, the nurse or the doctor injecting the vaccine, to believe that she had consented? And here the court said yes. By holding out her arm, it was quite reasonable for the person giving the vaccinations to believe that she is consenting to being vaccinated. So this would be a successful defense here to some sort of battery or assault claim, whatever Ms. O'Brien was asserting, because there was consent. Another defense to intentional torts is self-defense. Now, this is another point that commonly comes up in criminal law. In criminal law, you're probably going to cover self-defense, and especially when you can use deadly force in self-defense. So just be sure you're aware of when you're using it in a tort scenario versus a criminal law scenario. So in a tort scenario, a defendant is allowed to use self-defense, force in self-defense, when they believe it is necessary to protect against the unlawful use of force. Notice nowhere in that definition does it say deadly force. There's two different types of self-defense. There's mere force that could be used in self-defense, and then there's a different standard necessary for deadly force. But you're always allowed to use mere force in self-defense. So for instance, if I see someone trying to punch me in the face, and I raise my arm and I knock their hand away, I knocked their hand, I probably committed a battery. So if they sued me for battery for having knocked their hand away, I can raise self-defense and I can say the reason I knocked your hand away is because I reasonably believe that force was necessary to prevent you from punching me. So I acted in self-defense. If the force approaching the victim is deadly force, that's when the victim could potentially respond with deadly force. A similar defense is available to defense of property. The big distinction, though, being that you can never use deadly force to defend your property. You can use some force, reasonable force, to defend property, but not deadly force. There's a specific note here about a merchant's defense that says that a store owner is permitted to detain a person that they reasonably believe has stolen goods. This is probably going to be a defense to false imprisonment. So if, let's say, I walk into a store and the store owner thinks that I stole something, so they force me to sit in the back office until the police arrive, and I sue them for false imprisonment. I say, you confined me. I knew I was being confined. You had no good reason to confine me. As long as the confinement is reasonable here, they get a privilege or a defense, meaning that they're allowed to detain someone that they reasonably believe has stolen goods from their store. And this would work as a defense to false imprisonment. The last one is necessity. And you can see that there's a difference between public necessity and private necessity. Public necessity is where the defendant acts and commits some sort of harm or damage, but they claim that they did it for the greater good. So think, for instance, that there's a wildfire coming toward a neighborhood, and the defendant burns down the houses on the outside of the neighborhood. They commit some sort of trespass to land, conversion. They destroy these houses, but they say they did it for the greater good. They did it so that the fire wouldn't have anywhere to continue spreading, and they save the rest of the neighborhood behind those houses that they burned down. that defendant, should he be charged with some sort of tort for having burned down the houses, could raise public necessity as a defense. Public necessity is a complete defense, so that defendant is not liable and doesn't have to pay for any of the harm that he caused. Private necessity, on the other hand, is where the defendant acts to save him or herself or does something for his or her own interest. So for instance, if I'm being attacked or chased, let's say, by a vicious looking dog, and I run into my neighbor's backyard, technically I'm trespassing. I didn't have permission to go into my neighbor's yard, but I can claim that I'm acting in necessity because I'm being chased by this dog. This is a defense, so I won't be liable for trespass to land. But if I commit any damage to my neighbor's property while I'm on it, then I would have to pay for that damage. That would be the distinction here. So public necessity, the defendant doesn't have to pay for any damage to the property. Private necessity, you still have to pay for the damage. Two final points about intentional torts. The first is the transferred intent doctrine. We focused on that intent element for some of those intentional torts that we looked at. Transferred intent allows someone to transfer their intent to commit one tort to a different tort. So for instance, if I intended to cause an assault, I just wanted to make someone think that I was about to hit them, but I accidentally hit them. I swung a little too hard and I ended up making contact. I didn't intend that contact. I only intended the apprehension, but the transferred intent doctrine says that we can transfer that intent to commit an assault to the tort of battery, and I could be liable for the tort of battery. The other point here is the tender years doctrine. Some jurisdictions have a specific rule that prohibits a child under a certain age from being held liable in tort. Usually a jurisdiction that has this type of rule sets the bar at around age 7. So children under the age of 7 cannot be liable for torts, but children over the age of 7 can. We'll talk about parents' liability for their children's torts at the end of this video. All right, so that takes us through intentional torts. Now we're going to talk about negligence. You're going to notice that negligence makes up most of this handout, and I'm sure when you start your torts class, if you take a peek at the syllabus, negligence is probably going to make up most of your torts class. This is the big topic that you're going to spend a lot of time on covering in torts class. It's a very complicated issue. There's a lot of nuances to it, and it's very common in reality. This is where a lot of our torts come from. This is probably the most common tort, is some sort of negligence cause of action. And so if you ever end up doing any type of personal injury law after you finish law school, this is where a lot of your law is going to come from. So negligence is the cause of action that you would bring against someone who doesn't use enough care in their conduct. So let's say, for instance, I'm driving my car and I'm texting and driving. I'm not paying attention to the road. I don't have my hands on the steering wheel, and I end up hitting a pedestrian. I didn't mean to hit that pedestrian, so there's no intentional tort involved here. I didn't intend to cause that harm, but I wasn't being as careful as I probably should have been while I was driving. A reasonable driver probably wouldn't have been texting and driving, probably would have kept their hands on the wheel. So that pedestrian could sue me, insurance issues aside, don't worry about insurance here, but they could sue me for the tort of negligence. Negligence has 4 elements that have to be proven in order to succeed in this cause of action. Those are duty, breach, causation, and there's 2 types of cause that have to be proven, and damages. And we're going to talk in more detail about each one of these elements. All 4 must be present in order to succeed in a negligence claim. So starting with the duty. Generally speaking, everyone owes a duty of a reasonably prudent person. This is also referred to as the reasonable person standard. It comes from the Heaven v. Pender case. In any conduct that you're engaged in, you have to be careful as a reasonably prudent person would. That doesn't mean you have to be perfect. We're human. We make mistakes, but you have to act reasonably. Well, what would a reasonable person do in these circumstances? How do we know what a reasonable person would have done? There are some factors to take into consideration in determining what a reasonably prudent person would have done. So, for instance, one thing to take into consideration is age. For children especially, the standard is going to be a little bit different. Rather than looking at just any old reasonably prudent person, for children, you can compare this child's conduct to a reasonably prudent child of similar age, intelligence, and experience. You wouldn't just compare this child to an adult and say, what would an adult have done in this situation? You would compare the child to another child, and you would say, what would a reasonable child have done in this situation? Now, there's an exception to that. If the child is engaged in an adult activity, so for instance, driving a car, now we don't care what a reasonably prudent child would have done. Now we will look to see what a reasonably prudent adult would have done in that circumstance. If the child is engaging in adult activities, we're going to hold them to the adult standards. Another thing to take into consideration is physical characteristics of a person. So for instance, if a defendant has one arm, we're not going to compare that person's conduct to an able-bodied, two-armed individual. We're going to say, what would a reasonable person with one arm have done in this situation? For professionals, they are held to a higher standard. So for instance, a doctor who allegedly committed some sort of negligence, we're not going to ask what would a reasonably prudent adult have done in this situation. I don't want to be the reasonably prudent adult in that medical situation. I have no idea what the doctor should have done. We don't want to compare the doctor to reasonable adults. We want to compare the doctor to reasonable doctors. So in professional situations, the professional is held to the standard and compared to what a reasonable professional would have done in that scenario. What would a reasonable doctor have done? What would a reasonable lawyer have done in that scenario? So it's a little bit higher standard for professionals. And then finally, in emergency situations, they will take the emergency into consideration. So it's not just what would a reasonable person have done in general, it's what would a reasonable person have done here in this same emergency or under these same circumstances. The law recognizes that people get stressed out in the context of an emergency, and they may not make the best decision in the course of that emergency, so they'll simply look to what a reasonable person would have done under very similar circumstances. The court will take things like custom into consideration in determining what the duty is, so exactly what conduct should have been undertaken. Custom is generally evidence of the duty of care. For instance, in the T.J. Hooper case, which you may read, there was an industry custom for ships to have radios on them. Well, there was a ship in particular, I believe the ship is called the T.J. Hooper. This ship didn't have a radio on it, and the ship got lost in a storm. And the people who were on the ship sued for negligence, alleging that it was irresponsible of the ship's owner or captain not to have a radio on the ship. And they pointed to the fact that most ships have radios on them. The court took the fact that most ships have radios into consideration. They said this is evidence that it would be the duty of the ship to have a radio. It's not conclusive though. In a professional case, custom is conclusive. So let's say for a doctor, for instance, if it's customary for a doctor to wear 2 pairs of gloves in the course of performing surgery, and there's a doctor in question who committed malpractice by not wearing any gloves, they had a duty, a conclusive duty, to wear 2 pairs of gloves. They didn't do that. So in a professional standard, the custom is conclusive as to what the duty is. In a non-professional standard, custom is simply evidence. With regard to duty to control third parties, there's generally no duty to control third parties. That is with the exception of some sort of special relationship. So, for instance, the owner of land may have some duty to control occupiers of land. So think like a landlord has a duty to control their tenants so that the tenants don't commit torts to other people. A prison has a duty to control its prisoners in a way that the prisoners don't end up committing other torts. A mental institution has a duty to control its patients in a way to make sure that those patients don't end up committing other torts. But generally speaking, there's no duty to control other people and prevent them from committing torts. And then finally, with nonfeasance versus misfeasance, there's also generally no duty to act affirmatively. You can't generally be sued for negligence for failure to act. So for instance, if you're at the beach and you see someone that looks like they need some help, they might be drowning in the lake, and you don't jump in to help them, you don't generally have a duty to jump in and help them. You don't have an affirmative duty to do something. So if you sit back and watch, you won't be held liable for any damage that occurs as a result of your not having got up. Now, there are some exceptions to this, specifically with volunteers or with there's some sort of special relationship. So for instance, if you're the lifeguard at the beach, you may have a duty because of the relationship you have with the people at the beach to get up and try to help. Also, if you get in the water and you start to try to help, you become a volunteer, you have a duty to continue that help as far as you reasonably can. Certainly, you don't have to cause harm to yourself. You shouldn't have to put your own life at risk to try to help that person. But once you start exercising help, you have a duty to continue that help. There are some specific rules regarding duty as it relates to owners and occupiers of land. Sometimes landowners are liable for the harm that occurs on their land, not because they did anything wrong, not because they acted in any particular way, but because of their status as an owner of that piece of land. This means that owners of land may have some specific duties as it relates to that land. And the duty that the owner of land owes to people who come on the land depends on the classification of the people. So how do we describe the person or people that come onto the property? The four classifications of people who might come onto a piece of property include undiscovered trespassers, discovered trespassers, licensees, and invitees. So if it's an undiscovered trespasser on the owner's property, the owner doesn't know about them and they don't have permission to be there, the owner doesn't have any duty to that person. So if the person gets hurt on the property, the owner is not liable, assuming that the owner didn't affirmatively act to hurt that person. For discovered trespassers, the owner has a very slight duty. If the owner knows or has reason to know that people will be trespassing on his or her land, the owner of land has to warn or make safe all unreasonably dangerous, artificial or man-made conditions that he or she knows of. So for instance, if I know that there's a down electrical wire in my backyard and I haven't cut my grass in a long time, so this downed electrical wire is kind of hidden in the grass, you can't really see it, and I know that some of my neighbors cut through my backyard from time to time to get to each other's houses, I have an affirmative duty to at least warn them. Hey, if you're going to cut through my yard, don't go near the electrical wire. I know the wire is there. It's an artificial condition. It's unreasonably dangerous. And I know or have reason to know that these people are coming onto my property. So I would be liable if one of those individuals happened to be hurt by that downed electrical wire. Licensees are social guests. So if I invite my friends over for dinner, I owe them a little bit higher standard. I invited them over. I know they're coming. So as the landowner, I owe them a higher duty. So with regard to licensees, the possessor must warn or make safe all concealed dangers that he or she knows of. So if I know, for instance, that the floorboard in my front hallway pops up and is a tripping hazard, when my friends come in the front door, I really should warn them. I should say, hey, watch out for that floorboard, because I know about the floorboard. So if I don't warn them of this concealed danger and they end up getting hurt by it, I, as the premises possessor, could be liable for their injuries. The last category is an invitee. An invitee is someone who either comes onto the premises for a commercial purpose or the premises is open to the public at large. This is most commonly seen as a customer at a store. So when I walk into the grocery store to buy my groceries, I am in the store for a commercial purpose. I'm going to be handing money over to this grocery store. Because they get a financial benefit from my presence on the property, they owe me the absolute highest duty. The grocery store here has to be extra careful when it comes to the safety of their invitees. The premises possessor here has to inspect the premises for dangers and warn or make safe all dangers that he either knows of or should know of. That means that the premises possessor will be liable if they don't make inspections. So when I go to the grocery store, if the people at the grocery store aren't regularly checking to make sure that there are no spills in the aisle, and there's a spill of something in the aisle that I slip and fall on, I could sue them for negligence because it was unreasonable for them to just leave that spill there. Not only do they have a duty to quickly clean the spill up, but they should be regularly checking to make sure that there are no spills in the area so that their invitees are safe on the premises. One twist on this duty element is the doctrine of negligence per se. Negligence per se comes up when there is a statute at issue and violation of that statute. We cover this in the duty section because it helps explain exactly what duty the person owed. So think, for instance, of a speed limit. A speed limit is a statute. There's a statute or a law that says you can't drive above this posted speed limit. So let's say the speed limit is 65 and I'm in my car and I drive 70. Well, I had a duty to drive 65 and I was driving 70. If my speeding causes an accident, the victim of the accident may be able to use negligence per se as proof that I breached the duty that I owe to other drivers on the road. The elements of negligence per se are that there's violation of a statute, the person within the class that is protected by this statute was injured, and the type of injury that occurred is the type of injury that the statute is trying to prevent. So here, I violated the statute by going over the speed limit. The person who was injured is another driver on the road. That's exactly who this statute is designed to protect. And the type of injury that occurred was this car accident. That's the type of injury this statute is designed to prevent. So therefore, this person could sue under a theory of negligence per se. And when they show these elements of negligence per se, they have successfully proven the elements of duty and breach. They show that I had a duty and that I breached that duty. So they would still have to show causation and damages. Remember, there are 4 elements to negligence. They still have to show those other 2 in order to succeed against me in negligence. But this doctrine of negligence per se helps them establish duty and breach. Speaking of breach, let's talk about the next element of negligence now that we went through duty. Now, normally breach is pretty clear. Once you establish that someone had a duty, the breach simply asks, did they comply with that duty or did they not comply with that duty? So was this person driving their car, driving within the speed limit, or were they driving over the speed limit? The doctor who should have worn gloves for the surgery, did the doctor wear the gloves or did he not wear the gloves? So usually once you establish the duty, it's pretty clear whether or not the breach has taken place. Sometimes, though, the circumstances are such that it's very hard to tell exactly what conduct the defendant did or didn't do, and it may be difficult to establish that a breach actually occurred. This is where the doctrine of res ipsa loquitur comes in. This doctrine helps a plaintiff establish a breach in circumstances where the circumstances surrounding the injury are really unclear, and the plaintiff can't quite point to exactly what the defendant did wrong. He can't point to the act that amounted to the breach. Res ipsa loquitur says, in this type of situation, if the plaintiff can show that this injury that they sustained was likely the result of negligence, or in other words, that this wouldn't have happened absent some negligence, and that it was likely the defendant who they've sued, who was negligent, was within this defendant's control, then this plaintiff has made a case for breach. And this doctrine of res ipsa loquitur allows them to establish that there was a duty and the duty has been breached. So they still have to show causation and damages, but they can use this if it would have otherwise been hard for them to show what the breach was. There was a case that you may cover regarding res ipsa loquitur, and in this case, the plaintiff was on the sidewalk walking past a building, and while the plaintiff was walking past this building, a barrel of flour, which was being lowered from above, fell on the plaintiff's head. So the plaintiff sued the owner of the building who was lowering this flour for negligence. Now, the plaintiff doesn't know exactly what happened. Did they not use a proper mechanism to lower the flour? Did they not use enough harnesses to secure the flour? Did they not have enough people lowering the flour? Was there a staircase that would have been better for them to lower the flour? We don't know exactly what happened and what went wrong, but what we can say here is that flour doesn't usually fall on people's heads without someone acting negligently. Also, this building was within the control of the defendant. The defendant was the one lowering the flour, and so we can contribute the negligence to that person. So we can say it was likely negligence, and it was likely the defendant. This would be enough for the plaintiff to establish duty and breach. So even though the plaintiff can't say exactly what went wrong, they can use this doctrine to benefit them and to make sure that their lawsuit keeps moving forward. The last part of breach is the learned hand formula. This comes from the United States v. Carroll towing case. This is a very famous case because of this formula. You're most likely going to at least mention this formula at some point in your class. Learned hand is a judge who came up with a formula to establish whether a breach has occurred in instances where it's not quite clear if the defendant was careful enough or if the defendant maybe could have done a little bit more. And so learned hand's formula compares the burden of preventing the accident to the probability of an accident times the loss from the accident. So you take the likelihood or probability that an accident could occur times the loss. So how big of a loss is it? Are we talking about something like death here? Or is it just maybe like a bump on the head? The bigger the loss times the probability, the bigger the number on that side. And you want to compare this risk to the burden of preventing the accident. So if the defendant had just been a little bit more careful in acting here, given the great risk involved, they probably breached their duty. They should have done something else. So where the burden is outweighed by the probability times the loss, learned hand says this amounts to a breach and helps the plaintiff establish this element of negligence. The third element of negligence is causation. And as I said at the beginning, there are two pieces to causation. In order to establish negligence, the plaintiff has to show actual cause and proximate cause. Now, actual cause is looking for a factual connection between the breach and the injury. We have to show that the act that amounted to the breach is what actually led to the injury. The injury must have been caused by the breach, in other words. And sometimes this is referred to as but-for causation. And the reason that we call it but-for causation is because you can ask yourself, but for the defendant's actions, would the injury have occurred anyway? And if you say yes, that the injury would have occurred anyway, that means that the defendant's conduct did not cause the injury. Take, for instance, let's say that I'm driving my car and I'm texting and driving. And because I'm texting and driving, I'm not really paying attention. And a pedestrian jumps out in front of my car and I hit that pedestrian with my car. The pedestrian sues me for negligence, asserting that it was negligent of me to be texting and driving. And I say that the pedestrian jumping out in front of me was so sudden that even if I had been paying attention, I had two hands on the wheel, I had my eyes on the road, the accident would have occurred anyway because I wouldn't have had any time to stop my car. So if I can show that the accident would have occurred anyway, then the plaintiff cannot show that my texting, the breach, was the cause of her injury. Just because someone gets injured doesn't mean they can sue for negligence. This pedestrian might have been injured of their own negligence, as a result of their own negligence. I am not automatically liable for their injury just because they got hurt. It's only when I did something wrong, I breached my duty. So this is where we're looking to see if the breach relates to the injury. Now, this actual or but-for cause test doesn't always work. There are some instances where we have to use a different test. For instance, if there are multiple causes, we have to use the substantial factor test. Here, you look to see if the defendant's breach was a substantial factor in causing the harm. So for instance, let's say there are 3 houses in a row, A, B, and C. And A and C simultaneously light their houses on fire for whatever reason. And those 2 fires come to the middle and come together to burn down house B. So if you use the but-for test here, no one would be liable for negligence. If you said, but for A's fire, would my house B still have burned down? The answer is yes, it would have because of C's fire. Same thing with C. If you say, but for C's fire, would my house still have burned down? And the answer is yes, it would have burned down. Therefore, C cannot be negligent. So because the but-for test would fail us here, we would use the substantial factor test instead. So if either fire was a substantial factor in causing the harm, then that person who started that fire would be liable. Another scenario is where we use the alternative causes test. So if you have 2 or more defendants who are all negligent, but you don't know which negligence caused the injury, the plaintiff will join all of those defendants in one lawsuit, prove that all of the defendants acted negligently, and then the burden shifts to the defendants to prove that they did not breach their duty or that their breach was not the cause of the plaintiff's harm. There's a case here called Summers versus Tice, and in this case, 2 hunters, actually it was 3 hunters, 3 hunters went out shooting. 2 of them were acting negligent. They weren't looking where they were shooting their guns negligently, wildly, and the 3rd one got shot. The 3rd hunter was injured by one of these 2, but he doesn't know which one. He has no idea which of those 2 fired the bullet that actually hit the 3rd hunter because they were both negligently firing their guns. So in this case, hunter number 3 can sue the first 2, show that they both acted negligently, and now the burden shifts to them to prove that they did not cause hunter number 3's damage. The market share liability doctrine comes up where you have multiple defendants and it's impossible to determine exactly which defendant made the product that was defective. This comes up in a products liability case, and oftentimes this doctrine is used in like drug cases, for instance, pharmaceutical cases. So if, for instance, I took a pill of, let's say, acetaminophen and it was defective and I had an adverse reaction, and I want to sue the person or the company that made that particular pill, but there are 5 drug manufacturers that all make that exact same formula of acetaminophen, and I can't say exactly who made this particular pill that made me sick, I could sue all 5 of them, and the market share liability doctrine says that they're all liable according to the portion of the market that they share. So if number 1 makes 20% of the acetaminophen that's on the market, number 1's liable for 20% of my damages. If number 2 makes 25% of the acetaminophen, number 2 is liable for 25% of my damages, and so on and so on. So that's actual cause. Actual cause, again, is looking for a factual connection between the breach and the harm. Next, we have proximate cause, and you have to have both. You need both actual and proximate cause to be able to sue for negligence. Proximate cause looks at whether the harm is the foreseeable result of the breach. So lots of things could be the actual or but-for cause of someone's harm, but we don't want to hold someone liable for some sort of harm that there's no way they could have foreseen coming or could have therefore prevented. So this is where proximate cause comes in. It limits causation to only that which is foreseeable. So what typically happens here on these wacky law school hypotheticals is that something extraordinary or unforeseeable comes in and potentially cuts off the chain of causation. If it's so wacky and unforeseeable that there's no way we could have imagined this ever happening, there's not going to be any proximate cause here. There are some things that the courts have highly litigated and have decided are in fact supported by proximate cause. So for instance, if I'm driving negligently and I cause a car accident, certainly if that other person in the other car breaks their bones, that is foreseeable. That's exactly the type of injury that you foresee happening from negligent driving and resulting car accidents. The courts have said it is also foreseeable that that person with the broken bone could go to the hospital and suffer additional injuries at the hands of some doctor that commits malpractice. So I, the original tortfeasor who caused this accident negligently, I would be liable for the broken bones and any subsequent harm that occurs at the hospital because of that malpractice, because the court has said malpractice is foreseeable. The court has also said that rescuers are foreseeable. So if I negligently cause a car accident, a rescuer stops and tries to, let's say, pull the victim out of the car, but drops the victim and causes even more harm. Rescuers are foreseeable. So I, the original tortfeasor, I'm on the hook for the original damage and the additional damage that occurred as a result of that rescuer having dropped the victim. The very famous case that I can pretty much guarantee you will read in your torts class on this topic is Palsgraf versus Long Island Railroad. So in this case, what happened was there was a passenger who was about to get on a train and he was carrying a box of explosives and he was about to miss the train. The train had started to leave the platform. So a worker for the railroad company walked up behind the passenger and gave him a push. He tried to push him up onto the train. And when the worker pushed the guy, the man dropped his box of explosives. The explosives exploded. The explosion caused the platform to shake. And a ways down the platform, this very heavy scale fell as a result of the shaking. And it fell on Mrs. Palsgraf, our plaintiff. So Mrs. Palsgraf sued the railroad company. What did the railroad company do? They pushed that other passenger onto the train. So in terms of proximate cause, you want to look at what conduct was the breach. The push is the alleged breach. Is it foreseeable from pushing a passenger onto a train that another passenger way at the other end of the platform could potentially be hurt by a scale that falls on that passenger's head? Not really. So the court here said that is way too attenuated. There is no way the railroad worker who pushed passenger number one could have foreseen that as a result of the push, Mrs. Palsgraf way down at the end of the platform would be hurt. There was no proximate cause there, and so Mrs. Palsgraf could not sue the railroad for her damages. Speaking of damages, that takes us to the fourth element of negligence. In order to sue for damages, the plaintiff must show actual harm. So it's not enough to just say that they suffered emotional distress. If Mrs. Palsgraf had just, let's say, been a little distraught by the fact that she saw this explosion go off on the train platform, she could never have even attempted to sue for damages. But here she did have damages. The scale actually fell on her. She had physical damages, which is necessary for a negligence claim. You have to have actual damage. Economic damages are those related to the loss, so the plaintiff can recover for things like medical bills and lost wages. And non-economic damages are compensation for things like pain and suffering, things that aren't easily measurable. As long as there's actual damage, the plaintiff can potentially recover for both. So the different types of damages include actual or compensatory damages meant to compensate the victim for their harm, Nominal damages, which are recoverable if the plaintiff doesn't have any actual damage, but can successfully sue and show liability. Nominal damage recognizes that the plaintiff wins, that they can succeed, but didn't really have any harm to compensate. So for instance, if I walk onto your front yard, I technically committed trespass to land. So you could sue me for trespass to land. You're not going to recover much, though, if you didn't have any actual harm. The court might award you some nominal damages, like let's say, for instance, they give you $1 to recognize the fact that, yes, you can succeed in your cause of action, but because you don't really have any harm, you're not going to get anything. You're not going to get nominal damages in negligence cases because you have to show actual harm to even have a negligence case. And then punitive damages are meant to punish the defendant. Again, we do not have punitive damages in negligence cases. Punitive damages only come up if the defendant acted reckless, maliciously, or willfully and wantonly, usually for our intentional torts. Otherwise, you don't have punitive damages. You're also most likely going to discuss here the eggshell skull rule, which says that recovery is allowed if at least some of the harm is foreseeable, even if the extent of the harm was unforeseeable. Like, let's say, for instance, I'm driving my car and I'm texting and driving and I get into an accident and the other driver gets hurt and the other driver has extremely brittle bones. And so as a result of this injury, of this car accident, they break every bone in their body. A normal person probably wouldn't have broken any bones, but this other person broke every bone. They had extensive injuries. My negligence caused their extensive injuries, and I am liable for all of it. The fact is that some injury was foreseeable as a result of my negligent driving. So even though the extent of the injury was unforeseeable, I'm still on the hook for all of it. I mentioned negligent infliction of emotional distress at the beginning when we talked about intentional infliction of emotional distress. Negligent infliction of emotional distress is its own cause of action. So it's not just a version, well, it is a separate version of negligence. It's a separate tort. So you have your tort of negligence, and then you have your tort of NIED, or negligent infliction of emotional distress. In an NIED claim, the plaintiff is suing because the defendant negligently caused emotional distress. So compare this to intentional infliction of emotional distress. Here, there was no intent to cause emotional distress. There was mere negligence. The piece of negligence that we're going to carry into negligent infliction of emotional distress is the need for actual harm. That's the big piece that differentiates IIED from NIED. IIED, as long as the plaintiff suffered some emotional distress, they can recover. In an NIED claim, the plaintiff must have some actual damage. So for instance, let's say the plaintiff has a heart attack as a result of the emotional distress, or suffers a miscarriage as a result of the emotional distress. That would be enough to show actual harm necessary for a negligence claim. If they don't have that actual harm, if all they have is emotional distress, the plaintiff cannot recover for negligent infliction of emotional distress. Just like we had defenses to intentional torts, we also have defenses to negligence. Now, you would only use these in defense of negligence. You would not use a negligence defense to an intentional tort, and you would not use an intentional tort defense to a claim of negligence. They stay with each other. Intentional tort claims stay with intentional torts. Negligence defenses stay with negligence. So the defenses that we have here, the first two go hand in hand, contributory and comparative negligence. Jurisdictions pick one or the other. So most jurisdictions have adopted either contributory or comparative negligence. It's important to know both in law school because when your professor tests this, they're probably going to test you in some hypothetical jurisdiction, and they're not going to tell you which one this jurisdiction has adopted, giving you an opportunity to show your clear understanding of both of these defenses. But essentially, contributory negligence is a defense that the defendant will raise And the defendant will argue that the plaintiff contributed to his or her own harm. So the defendant might say, yes, I was negligent because I was texting and driving, but you were also negligent because you had a stoplight, you had a red light, and you walked right out into the middle of traffic. You contributed to your harm. In a contributory negligence jurisdiction, if the plaintiff is even a little bit negligent, no matter how little it is, any negligence on behalf of the plaintiff will bar that plaintiff from being able to recover anything. So if I'm texting and driving and I'm 90% at fault, and the plaintiff is 10% at fault for walking into the middle of oncoming traffic, that plaintiff gets nothing because they contributed to their own harm. Comparative negligence jurisdictions soften the blow a little bit. In a comparative negligence jurisdiction, the judge or the jury will compare the percentages of fault attributable to the plaintiff and the defendant. And they'll give each person a percentage. So, for example, they'll say defendant Heather was 90% at fault for causing this pedestrian injury, and the plaintiff, the pedestrian, was 10% at fault. And what happens is that they take the plaintiff's total amount of damages. So let's say the plaintiff has suffered $100,000 in damages, and they reduce the plaintiff's damages that they can recover from the defendant by the percentage of the plaintiff's fault. So if the plaintiff was 10% at fault, they get 10% less from me, the defendant. So they get $90,000 of their $100,000 in damages. The third defense to negligence is assumption of the risk. If a defendant knows of a risk involved in an activity and voluntarily assumes it, generally they cannot recover damages. So for instance, if you decide to go bungee jumping, you know that there's a risk that that cord could snap. And so you're very likely going to be unable to recover from the bungee jumping company running that type of activity and say that they were negligent in, let's say, allowing you to jump off the bridge or whatever you jumped off of. Now, assumption of the risk aside, you probably also signed some sort of waiver agreeing that you wouldn't sue them. But this is a common law defense that the bungee jumping company could raise and say that you knew what you were getting into, you knew the risk involved, you assumed it, we cannot be held liable. Our negligence is not the issue here. A couple of final issues that you may or may not go over in your torts class. These are usually kind of last minute things that either get brought up if you have extra time at the end of the semester, or they'll get kind of sprinkled throughout the semester depending on the different cases that you read. The first one being multiple defendant issues. When you have multiple defendants, that could affect how and from whom the plaintiff recovers their damages. So this assumes that all of the defendants were in fact liable. So let's say plaintiff gets injured and 3 defendants were liable and acted negligently to contribute to the plaintiff's injuries. In a joint and several liability jurisdiction, the plaintiff can recover all of their damages from any one defendant. So if plaintiff had, let's say, $100,000 in damages and there's 3 defendants, and each defendant was 33% liable for the plaintiff's injuries, plaintiff could recover $33,000 from each one, or plaintiff could go after the one with the deepest pockets and get the entire $100,000 from any one of those defendants. That second example where the plaintiff gets the $100,000 from any of the defendants is joint and several liability, meaning that the defendants are not only on the hook for their own portion of the damage, but could also be forced to pay for the other defendants' portions of the damage. Now, this is different in a several liability jurisdiction. In a several liability jurisdiction, each defendant is only responsible for his or her portion of the damages. So the plaintiff could only get $33,000 from a defendant, not a penny more. And the plaintiff would have to go after each individual defendant to be able to collect their entire $100,000. Employees and agents may trigger issues of vicarious liability. Vicarious liability is the idea that an employer is liable for the tort committed by their employee or agent. So even if the employer did nothing wrong, simply by virtue of the relationship between the employer and the employee, the employer might be forced to pay or might be liable for whatever tort the agent committed. There's a lot more detail to that doctrine, and there's probably other elective classes offered in your school that go into more detail on that point as well. This is something that may just be briefly brought up in a torts class. Parents are not generally vicariously liable for their children. So if a child commits, let's say, a tort, an intentional tort or negligence, the parent is not vicariously liable for that. Children may or may not be liable for their own torts. We talked about the tender years doctrine, depending on the jurisdiction. The very last topic in this handout is strict liability. Strict liability comes up when a defendant is engaged in certain activities, and typically these activities involve such a high degree of danger that no matter how careful the defendant is, there's a risk involved. And when the defendant is engaged in these type of activities, we hold the defendant strictly liable, meaning that if something goes wrong, the defendant is on the hook. It doesn't matter how much care was exercised, any mishap with regard to this activity will result in liability. The common types of activities that you'll talk about, there are three with regard to strict liability, are abnormally dangerous activities. That's number one. So for instance, if a defendant is transporting nuclear explosives, there is no way to be extremely careful with regard to transporting nuclear explosives. So no matter how much care is exercised, if anything goes wrong, the defendant is strictly liable, and anyone who was injured can recover from that defendant. Another one is wild animals. So let's say, for instance, I decide I need a pet tiger. And so I have a pet tiger in my backyard, and I am trying to be extra careful so that no one gets hurt by my pet tiger. So I put up a triple fence, and the fence goes 20 feet up in the air, and there's barbed wire at the top of the fence, and there's a lid over the top of the fence so that there is really almost no way this tiger can get out and hurt someone. Nonetheless, the tiger gets out, the tiger hurts someone. No matter how careful I was, even though I exercised the utmost care with regard to this tiger, I am strictly liable for any injuries that resulted as a result of my ownership of this wild animal. The last one is products liability. Products liability with regard to manufacturers or people in the distribution chain also gives rise to strict liability. So no matter how careful they are, if a product comes out defective and someone gets hurt, that person can recover against the manufacturer or the distributor of that product under a theory of strict liability. So I hope you found this discussion helpful as it relates to torts. This is not a topic that most people have a ton of familiarity with going into law school, but it is kind of interesting. You get a lot of fun fact patterns in your torts class, and it can be a very interesting class.